we have gathered here today to talk about tenant screening. We are going to touch on crime and tenant screening and also a couple other sticky situations that often pop up to make sure that you know what to do so that your tenant screening process aligns with the Fair Housing Act. Before we jump into the presentation, we do have a quick poll. I would love to learn a little bit more about you. So if you could, please let us know how many rental units you own and manage. And if you've attended a webinar with us before, if you have an account with TurboTenant, and what you're currently using to screen applicants. I would love to know this information, one, because I'm kind of nosy, and two, because it's always nice to know who we have into the room. That makes it easier for me to try and tailor information that might be most applicable if we have like one group that has a ton of experience, or if this is a group where we have mixed levels of experience. It's just always good to know. So I'll give you about, I'll say a cool 20 seconds more. It's a pretty quick poll, and there are no wrong answers. So please take your time. All right. So if you want to get your answers in there, about 5 seconds remain. This is pretty great. I always love seeing the spread of what people have going on, and I will go ahead and share that with you as well. So unsurprisingly, we have a bulk of folks with 1 to 3 units that they own and manage, but we also have some people with over 101 units. This is why I very much encourage you to use the chat, talk with each other. It's just such a good resource and really love this community. So leverage it wherever you can. Also, this is a great split. So 60% of you are joining us for your first TurboTenant webinar. With that in mind, I'm going to introduce myself. My name is Krista Ruther. I am the Senior Content Education Manager here at TurboTenant, which means I have the pleasure of deep diving on topics for you guys and putting together webinars every month, along with podcast scripts, newsletter, bits and bobs sometimes, although largely that's our writer Ryan, and so many other forms of content that we hope you enjoy and can use for your business. And most of you have a TurboTenant account. That's great. I'm going to touch on some of the things you can do with TurboTenant, especially for those of you who have not yet signed up. So we will keep that in mind as we move forward. There are a few key focuses that I want to make sure you take away from today. First and foremost, I want you to understand why it's really critical for you to have a repeatable tenant screening process. Not only is it going to save you time and stress, but if you do get, let's say, a fair housing complaint, having something written out and understanding the thinking and what HUD wants from you is going to be really helpful in trying to ensure that you don't have to pay a fine and that you are aligning with the Fair Housing Act. Additionally, you should set really clear policies to address some of the trickier situations that could pop up, whether that's someone's criminal history or if someone has no social security number, no credit score, etc. We're going to move through all of those topics today and more. And lastly, something that I really want you to keep in mind as we go, and that I will be weaving through this presentation, the Department of Urban Housing and Development, or HUD, they want you to be able to understand the why behind your tenant screening process. So we are going to talk about that when it comes to things like whether or not you can ban felons on a blanket ban, and some of the other bits and bobs that are a little bit trickier and that you might not know off the bat. Also, I should let you know, Halloween is my favorite holiday, and it is also my designer's favorite holiday. So we have a lightly spooky deck. All treats, no tricks. We're going to teach you what you need to know about tenant screening, starting with the basics. So when we talk about tenant screening, we know that it's important because it's the best way for you to protect your investment property outside of insurance and things like that, right? This is a process that you can own and manage. It can be really easy, but if you're just starting out, it might also seem really challenging because there are all these questions about what you can ask, what you can't ask, excuse me. So I want to make sure that you understand as much as possible. I will say, I am not a lawyer. I know, I'm just a good-looking researcher. And that means that anytime I can, I'm going to remind you that you will need to check your local and state laws to ensure that the advice I'm giving you is compliant. There are so many different laws, especially regarding the Fair Housing Act and some of the nuances regarding protected classes that just vary from place to place. And I never want to lead anyone astray. So you will hear me repeat that quite a bit. Check your local laws because this is more of a national overview, although there are some spots where I'll highlight things that I know about specific states. With that in mind, Let's go through the snappiest fair housing overview. First and foremost, the Fair Housing Act was enacted on April 11th, 1968, following the assassination of Dr. Martin Luther King Jr. Inherently, the Fair Housing Act is really intended to protect tenants, homebuyers, and anyone seeking loans from discrimination based on 7 protected classes. Now, these are the 7 protected classes nationally. However, there are also protected classes for individual states and areas. So make sure that you are, again, checking those laws to ensure that you are compliant. So, for example, here in Colorado, where I am from, veteran status, ancestry, and source of income are additional protected classes. So when in doubt, you need to go with the information that is more specific in terms of the laws. So if your county has additional protected classes, make sure that you are following those in addition to the 7 national protected classes. With this in mind, the Fair Housing Act inherently says that you cannot, again, discriminate against anyone for any of these reasons that you see based on the protected classes. And in this case, it would be an unfair housing practice and unlawful to refuse to rent or sell, aka making housing unavailable to someone based on their protected class. If you give them unequal terms or conditions of the rental based on a protected class, the refusal to allow reasonable accommodations or modifications to accommodate disabilities would be falling under that disability protected class. Also, if you misrepresent availability, if I come to you trying to rent a unit and you turn me away because I'm a woman, that is not going to bode well. That will be a violation of the Fair Housing Act. And as I have here, landlords can actually face fines of up to $16,000 for their first fair housing violation. So it is very important to understand what these laws are and try to abide by them to the best of your ability. Also, as a housing provider, you have a chance to create an equal and equitable experience for folks, and that's a really big privilege. So I hope you take it very seriously. We'll go through how you can do that while protecting your business. Something to note while we are here, we'll get into some of the exemptions of the Fair Housing Act because I know that always comes up when we talk about it. But even if you are exempt from the act, you are not allowed to advertise a preference against or for any of these protected classes. So that'll make more sense as we go through the actual exemptions, but something to bear in mind. All right. One last note regarding source of income protections. 18 states, Washington, D.C., and roughly 120 municipalities have source of income protections because it falls under disability, according to our paralegal, who I adore. So keep that in mind that many of these states haven't enacted a statewide protection. And you want to make sure, again, that you are up to date on your local laws to align yourself with the Fair Housing Act in your area. A good place to get started is turbotenant.com/state. Again, that's just a good spot to start. Make sure that you are also perhaps going to your .gov site and checking it out from there. All right, so we've gotten a really snappy overview of the Fair Housing Act. Quick, if you want to learn more, we do have a course. We dive into it for about 2 hours. But let's keep it trucking and talk about why setting criteria is so important. Inherently, you want to make sure that your tenant screening process is repeatable and largely the same for each renter, although that doesn't mean making blanket judgments, particularly regarding anything that touches on those protected classes. So that means you can have very specific set criteria regarding credit score, regarding eviction history, but you also need to understand where to do your due diligence and the types of notes you should keep and things you should look out for, just in case there was a complaint, so that you can speak eloquently to the process that you have set and why you are doing it that way. All right. So now, the age-old question. Are you exempt from the Fair Housing Act? We have a quick little poll to deploy here. Let's see. Yep, here we go. Don't you worry. I'm a great multitasker. So, are you exempt from the Fair Housing Act? Yes, no, I'm not sure. I'll give you a little bit of time to fill this out. I always find the answers to be really interesting. And then, of course, I will actually let you know the qualifications to be exempt from the Fair Housing Act, and we can chat about them. While you are doing that, Let's see. Actually, I can't see the poll. Oh, yes, I can. All right. Checking out the chat while you're filling this out. All righty. Couple questions. Can I ask for pay stubs, award letters, Section 8 certificate, or okay. So Robert, let's I see that you sent this question to hosts and panelists. So I'm going to answer the first part, and then I'm going to give you a little bit of information on the second part, right? So for a Section 8 certificate, you can absolutely ask for pay stubs. The way that Section 8 works, depending on if you are in a state where you are applying to the program as a housing provider, or if you are someone who can have applicants come with their voucher and try and get into your rental, you can absolutely still screen them. I do think it is a mistake to think about Section 8 as being only drug dealers. That's a really sticky road to go down. And we're going to treat this whole tenant screening discussion with empathy and kindness. You know, we're not going to make any kind of statements that are inflammatory or otherwise offensive. So please bear that in mind. If you'd like to learn more about Section 8 and how it works, we actually have a couple of webinars on that. So please do check them out. Okay. Loving this chat about source of income. And I should say too, if you would like me to answer your questions for the Q&A, the best place to put them is in that Q&A line, because the chat just moves so fast that sometimes I have pause points and I can check them out like right now. But otherwise, if you want them all in one spot, the Q&A is going to be a good one. I'll answer one more question. I'm ending the poll. Let's see, Alan, can I adjust my rental criteria like income and credit score from time to time? For some reason, I felt like my criteria was a bit too high and I'm thinking whether I should lower it. Yes, you can absolutely change your rental criteria. I would say make a note of it. If you have a TurboTenant account, you can store documents for free. So I would highly recommend going in there, typing up a quick note. It could just be bullet points saying, okay, I'm looking for credit ranges in these scores. I'm also looking for this income level XYZ. And if you change it, update that doc. All right. Okay, so let's go ahead and share these results. Most of you say, no, I am not exempt from the Fair Housing Act. And most of you are absolutely right. A fair number are not sure. That's okay. We are going to go ahead and go through whether or not you are actually exempt. Let's see here. All right. Loving all these chats. Okay. Okay, wait, actually, before I go on, Patty, I see your question about income. So the idea of source of income being a protected class means that you can't discriminate based on where someone is earning their money. Although, again, make sure that you are talking to your local HUD offices if you have questions specifically about your unique situation or an applicant who pops up. I would also recommend pulling in a real estate attorney if you're worried. They will give you more information. So you can still deny housing to someone who can't afford your unit, but if they can afford your unit, and let's say they are a pole dancer, you wouldn't be able to say, well, I don't like that you're earning money as a pole dancer, so you can't have this unit, right? However, Robert, if they are earning money through like drug dealing, that is a very different conversation because that's an illegal process of actually earning money. So they wouldn't be able to, if they're doing something illegally, then that can't usually translate into the tenant screening process in a positive way. But again, check your local laws, talk to your local HUD office. They are very helpful. All right. Yes, thank you, Gregory. Okay, we are trucking along. So when it comes to the Fair Housing Act, there are actually some exemptions. Again, this is just a crash course. I always want you to go ahead and use this as a jumping off point, but you can certainly get more into the weeds with your local HUD office. They are very accessible. First and foremost, if you have an owner-occupied building with no more than 4 units, meaning you are living in one of the units and you have up to 3 other units available, you are technically exempt from the Fair Housing Act. Same with any single-family homes that are sold and rented by the owner without any real estate agent or realtor. Real estate agents and realtors, well, realtors specifically, are held to a code of ethics, which is why if they have any involvement, you kind of get that passed along and you are not exempt from the Fair Housing Act. Otherwise, if you did it alone, you could be, right? And lastly, here we have housing operated by religious organizations and private clubs that limit their occupancy to members. I have here that you may be exempt from the Fair Housing Act because, again, it can be kind of sticky to suss out whether or not you actually are exempt. And as I mentioned earlier, even if you are exempt, you are not allowed to advertise a preference for one protected class or a discriminatory stance against a protected class. So, for example, let's say I have a duplex. I live in one half, and I only want to rent to other women for the other half for my own safety, let's say. I would not be able to put that into my listing. That would be discriminatory, and I could get in trouble for that. However, as I screen tenants, I could move women forward in this very specific case, assuming that I double checked with my local HUD office and deny anyone else. All right. So very, very few landlords actually fall into any of these categories. So that's why I think it's so critical to really understand the Fair Housing Act and keep up to date with any kind of updates in your area or on a national scale, although there haven't been too many national scale updates in a while. Okay. So we've touched on all of that. I hope you're feeling a little bit more confident about the Fair Housing Act so that we can get into some other tenant screening basics. So we're going to actually start with the marketing of it all, right? And the reason for this is because you don't just screen tenants out of the blue. You need to make sure that any of your listings are aligned with the Fair Housing Act and they kind of set your applicants up for success. Not only does that help them feel like they are spending their time wisely applying to places that align with what they have going on, but it also saves you time because then that way people can screen themselves out without ever sending you a message if they don't align with one of your key qualifiers. So a key qualifier in this case could be something like no smoking or pets limited to 2 cats or 1 small dog under 50 pounds. Again, things that are in line with the Fair Housing Act, but are specific to your unit, depending on what your policies are. The more information you have there in a really quick bulleted list, the better people will be able to self-qualify. I would also say you should specify what your screening process entails. For example, if you say every applicant must complete a background credit check and eviction history report, then that lets people know, hey, I know my background doesn't look great, or I know that I have a lot of evictions on my record. I'm not going to waste my time or this landlord's time. I'm going to move on to a different property, right? Another great time saver is an automatic pre-screening tool. I will go over some of the questions that we have on TurboTenant's automatic pre-screening tool. But before we do, I have this handy dandy GIF here. I'm really proud of this. Our team built out an AI-generated property description piece of technology so that you can input your address and inherently click a couple of buttons. And we have trained this AI along with our Fair Housing Act course so that it can produce something for you that is both eye-catching and aligns with the law. Now, as with any piece of AI, I highly, highly encourage you to read through and make sure it matches up with the expectations and laws in your area before publishing. But it's a really handy tool, especially if you're not a prolific writer or you're just feeling a little bit tired that day and you don't want to try and figure out what tenants want to see to try and get your next favorite tenant. This is a great way and it's free. You can just click in, play around, and see what it comes up with. All right, back to the pre-screener. So the reason I like a pre-screener is, again, the way that we do it here at TurboTenant. When someone indicates that they are interested in your property, we fire off this pre-screener to collect quite a bit of information so that you can tell at a glance if this is someone who should move forward and you want to invite them to apply, or if it's not a good fit and you don't want to move forward with them, right? So specifically, we ask for things like their contact information, if they're employed, their monthly income, when they actually want to move in, pet information, smoking status, et cetera, et cetera. It also gives them a spot to ask you any questions about the unit, which can be really helpful. So you can see at a glance, high level, okay, this aligns with when my next tenant or when my current tenant is going to be moved out, and I can turn around the unit by then. You know, they should qualify based on this income. Okay, they do have pets, and you could start to match things up without having to go through that initial back and forth. So you have set up your listing. It's looking great. It's going to the top dozen rental listing sites through TurboTenant. You're firing off pre-screeners, and now you're starting to get people that you're really excited about. And that leads me to my next poll question. How confident are you in your ability to screen tenants? I'm gonna go ahead and get this here. Okay, am I? Oh, it's doing it. Lexi, you are so good. Okay, you guys should be able to see it, I think. If you can't, let me know in the chat. Very low confidence. That's okay, Jerry. We are going to help you get really confident. Braden's feeling good. Okay, and you're not seeing it. Okay, let me see. Thank you for letting me know. Sometimes technology is a good friend, and sometimes it's a little stinker. There we go. Thanks, Lexi. All right. Please click into the poll. Would love to know. I will be taking some of these questions. Okay. David, can you deny smokers? So if you have a no smoking policy, you can absolutely say, all right, this doesn't align. We are not moving forward, and that should be fine. Now, the way that I would word it specifically in your listing is to say no smoking policy. There's been some debate and some back and forth about whether or not saying no smokers violates the Fair Housing Act or not. So just to play it safe, make sure you're saying no smoking. That refers to the action and not a person, and that should be pretty good. All right. Loretta says, I'm having trouble getting people to look at my answers in the chat. Loretta, it could be because you're messaging hosts and panelists. So make sure that you click over that blue button in the chat and toggle to everyone if you're trying to chat with everyone. If you are chatting with me, then I would say probably put it in the Q&A because I might miss it if it's just in the chat. Keith, so if I'm exempt from the Fair Housing Act, do I care on the no kids question? So I'm thinking that this means if you're exempt from the act, can you say no kids in your rental? Again, you can, if you truly are exempt from the act, and again, I would definitely check with your local HUD office to validate this. You wouldn't be able to put that information in your listing description, but you could move forward and potentially deny families. Again, I highly recommend talking with a real estate attorney and your local HUD office to make sure, because that sounds quite, I would never want you to get into a situation where you thought you were exempt and you weren't. People loving the tool. And yeah, Keith, you cannot, yeah, that Lexi's got it. So you cannot advertise that way. All right. So let's take a look here at this confidence question. It looks like most of you are at least somewhat confident, which is great. Hopefully by the end of this, you are all moved to that extremely confident stage. That is my goal. I know that there are a lot of layers to tenant screening, but again, I think knowing the framework that HUD wants you to take and moving through your process in that framework is going to be really helpful and help you feel more confident. All right. I appreciate you guys going through this. Let's keep it rolling. So we've talked a little bit about some of these components, but if you are curious, the things that we include in our tenant screening from TurboTenant are going to be a criminal background check, a credit check, an eviction history report where legally allowed. And if you are a premium landlord, you get additional income verification through Income Insights. That is where we basically go through TransUnion and we match up what the applicant self-reported for their income versus what TransUnion has in their records. And they're able to tell you if it's right on the money. It means, they're pretty much good or maybe within $500 of what they listed, or if they have a lower income that was listed or even a higher income than what they listed. I would also recommend that you interview former landlords. That can be especially helpful if you do have someone who comes in with an eviction on their record, and I'll tell you more about that when we get to that slide. But I would say when you're looking to complete tenant screening, try and pull in all of these different pieces, right? Again, most of them can come through your free TurboTenant account. If you are a premium landlord and you are subscribed, you get additional income verification, and interviews with former landlords is something that you can reach out and complete on your own. We do have a really fantastic blog about questions that you can ask former landlords. I am slightly biased because I wrote that blog, but I think it's pretty helpful to understand the framework of that kind of conversation. So please check it out. And Lexi, if you have a minute and could drop it in the chat, that'd be great, but don't stress. All right, so let's unpeel the layers here even further. When we are talking about a credit check, this is really just to show you what the applicant's financial history is and their current financial health. So we have a fancy little GIF here on the right. You can see what that looks like on the mobile device through TurboTenant. It's intended to give you a high-level overview, and then you can click in and you can learn more about specific financial situations that they have going on. So a credit check is going to include their credit bureau score, along with their employment history, fraud indicators, address history, payment history, collection history, and civil records where allowed, right? Anytime we can pull in those records for you, we absolutely will. Sometimes the laws change and TransUnion's availability changes, so it gets a little bit sticky depending on these external factors, but we want you to have all the information you need to make a good informed decision about who to move into your rental. When you're actually going through, there are going to be quite a few things that you see, and I have an example of a tenant screening report. But just so you know, you can see things like the types of accounts that they have open, the number of revolving charges that they might have regarding minimum monthly payments, installments, which are accounts with a fixed number of payments, inquiries, etc. Since you are here live, you will be getting a little sheet with all of these key terms defined for you. So if you are newer to tenant screening, it should help you move through and understand what you are seeing. But for now, let's talk a little bit more about how to set financial criteria. So I provided here some general rules of thumb, but as you're learning to find a good tenant, the first step is really to establish what kind of credit score range you want to accept. So oftentimes for folks, 516 above seems pretty good. And we have this little graph here so you can see kind of the general like low accept to accept, a conditional range as well. These are just guidelines. Every landlord can set their own credit score range, and feel free to do what makes sense in your area. A higher credit score generally denotes higher credit worthiness. So you want to make sure that you are keeping that in mind. This is a pretty good indicator of how this person treats money and debt. And of course, as so much of the landlord-tenant relationship revolves around payments, it's pretty critical that you understand how they view payments and debt, right? Um, so I would say, again, you get to establish your own score, but I do want you to bear in mind that if you reject an applicant based on their credit score or any of the information that gets pulled through their tenant screening report, you must send them an adverse action letter. I will tell you a little bit at the end how TurboTenant takes care of that for you, but it's something to keep in mind. I will also go over some of the verbiage that we use so that you know, even if you're not using our free service, what is expected of you. But for now, let's jump over to the rent to income ratio. Typically, and I say typically loosely, classical wisdom dictates that tenants should spend no more of 30% of their gross income on rent. However, I just published a press release this morning based on some original research that we did here at TurboTenant, and unfortunately, 53% of renters reported that they spend more than 30% on rent as of August 2024. About 19% spend over 50% or more of their income on rent. So although this is a piece of classical wisdom, it is definitely something that you want to pay close attention to because it's becoming less and less feasible in a lot of areas for tenants to stick to that rent to income ratio. However, this is another thing that by and large, you can set for yourself. I will say there are some counties and states where they have specific limits on the rent to income ratio that you are allowed to set. They kind of cap it. For example, California has one such cap. I don't remember if it's specifically LA County or if it's all of California. But that's why I always recommend looking at your local laws to be sure that you understand what is expected of you and what you can and cannot do. All right. Also, generally speaking, you are probably going to want to look for someone who either has old collection history or no collections at all. Many things stay on your record for up to 7 years. So, for example, bankruptcy, evictions. These things are going to be on your record for a long time if they move forward. If you have an applicant who otherwise looks great and they have, you know, a bankruptcy from 6 years ago on their public record, I would say ask questions, investigate, and see if they still can move forward or not. That is ultimately up to you. Having collections is not a protected class, so it's pretty important, but you also want to weigh it out with the timeline of it all, right? If they just declared bankruptcy last week, that's a bit of a different situation, but it's entirely possible for a situation that happened 6 years ago to have been resolved and the person to be in a better financial standing at this point in their lives. And if you're curious, you're like, I don't know how to find the rent to income ratio, Krista, that seems like a lot of math. I agree. So we built a calculator for you. When we send you over this deck, you can click right here. It's a free calculator. You can put in your information and it will spit out the figures that you need. All right. Now let's take a quick look at what a tenant screening report can be. So this is an example from, you guessed it, TurboTenant. Uh, you see here, this is, I know it's a bit blurry, but that's okay. I will be your eyes. Um, this is the in-depth version, so you can see things like the score factors. It gives you a little bit of information about why they are getting the score that you are seeing. And it also lists things like their eviction records, any kind of criminal history. And then you have this nice summary here that can kind of break things down for you. You can see what they owe, what's past due, along with any kind of trade lines. So these are accounts or lines of credit. You can get an understanding of how this is going, if they are paying off the debts that they already owe, along with any other kind of public records and addresses on file. I will say when it comes to employment, that is reported by the employers, and so that can sometimes lag. So I'd recommend collecting things like pay stubs and other kinds of direct payment information to validate this, in addition to the tenant screening report. Unfortunately, when you are relying on employers to put this information into the system, things can drag. So again, make sure that you are covering your bases by requesting additional information. It's always just a best practice, and it's usually something folks are doing anyway. Okay. So before we hop into tricky tenant screening situations, let's take a quick look at the chat if I can find y'all. There you go. Um, all right. So, how do you turn in move-outs with unpaid rent, utilities, and penalties? So, it is possible that you can report them to the credit bureau. I would say get a hold of the big three are TransUnion, Equifax, and Experian. I believe that they have a service where you can tell the credit union, or excuse me, the credit bureau, hey, this is what's going on. I would also say if it's a case where you are owed a significant sum of money, you might want to pursue that in court. Although small claims court doesn't always, it can be quite sticky. No one likes going through the legal process. So do keep that in mind. Sometimes folks find it to be more trouble than it's worth, but that's another way. And if it were to move through the court system, it would be on their record. Eric says, don't forget to look at savings balance as well as income. Sometimes people have money in the bank, but not as high of income. That's a fair point. And that's also why, again, I think it's important to see, what kind of cash flow is this person bringing in? So collecting pay stubs or asking for like Social Security benefits letter, etc. It's important to understand what they've got going on. All right. Looking for questions. Okay. Hypothetical, 3 TransUnion scores, 590, 610, and 615. I choose 615 for employment stability and FICO. Are 590 and 610 entitled to an adverse action letter? Yes, Paul. So anytime that you are pulling any kind of tenant screening report, you're using that information to make a decision, those people are entitled to an adverse action letter. And we'll talk about that a little bit more later too. Somehow I feel 3 times gross income is a bit too low considering tax and other expenses like insurance, gas, utility, food, groceries. Thoughts? Well, Alan, here's what's really tricky. Unfortunately, rents have increased to the point where wages have not kept up. So we are running into a situation where over 53%, well, 53% of renters have become cost burdened, which means that they are spending 30% or more of their income on housing. And then again, another 19% are spending 50% or more of their income on housing. So while I hear what you're saying, I think depending on your market, you might still have a viable group of like a viable tenant pool if your gross rent requirement, your rent to income ratio is higher. But if you're in a slower market or wages are low in your market, you could run yourself dry and have fewer choices or no choices. It's really about finding a balance with what's working in your area because that's going to vary market to market. Okay. All right. One more question, and we're going to keep it trucking. I appreciate you guys firing those into the Q&A as well. How does TurboTenant work? Does the applicant log on and use TurboTenant after I set up the account, or must I send them a link to use? That's a great question, Rayford. So basically, you put together your listing. It's really easy. You're thrilled. It's fun. We put it out to all the top sites. You are starting to get leads in. They're marked with which site they come from. They have the chance to click in and send you the pre-screener right away. You want them to move forward, you click a button to invite them to apply. That sends them a link so that they can get set up with a TurboTenant account of their own and input their own information. So you don't have to deal with their social security number or any of their sensitive private identifying information. We send it all off to TransUnion, and then you can review the report in TurboTenant directly. All right. These are great questions, and I really appreciate you throwing them in there. Again, I'm going to keep moving along, but I am going to keep pausing at points and asking or answering questions where I can. Okay. So now let's get into some of the trickier situations, the situations that have you looking like this wee witch who's kind of spooked. These are going to be things that you guys have asked me about in the past, and really just trying to move through and ensure that you understand them on a broad level. I will, as always, remind you to check with your local attorney and check your local laws if you find yourself in one of these situations, but we can kick things off with a couple of what ifs. So what if the applicant has no credit history at all? You might be thinking, well, Krista, we toss them out. That's no good at all. But I would urge you to remember that there are a couple situations in which folks might not have a credit score. So if they are a really new renter, let's say they just turned 18, they're going to school, you're providing student housing, they are very unlikely to have a credit report, or excuse me, a credit score, because you need to have 6 months worth of payments and history in order to generate a credit score. Similarly, on the other side, if you have elderly applicants, it's entirely possible that they are no longer using credit cards and they are just living off of other things. And so thus, if they haven't had any kind of credit-worthy history built up over the last 6 months, they will also no longer have a score. So if someone has no credit history at all, you can think through it beforehand and say, okay, if this comes up, I'm going to ask them specifically for their account information in terms of, I want some kind of pay stub, I want to see maybe a bank statement. That can be controversial because it feels a bit invasive, but it also gives you an idea of what they have in savings and their cash flow coming in and out. You can also ask for things like a benefits letter from either the VA, the Veterans, why can I not remember the A? Well, the VA is the office that helps veterans, so you can look for benefit payments from them through a letter, or you can ask for a Social Security benefits letter. There are so many different methods. We have a great number of articles detailing alternatives to your typical pay stub, even, if you just want to have that and they do have a credit history. So there are so many things you can pull in. That's the main takeaway. You can look at other criteria and determine if you want to move them forward or not. This is the type of thing that I would note down in your tenant screening document in a couple of bullets. Again, creating a repeatable documented process is going to help you in the long run. So feel free to throw a couple things in there if you were to run into the situation. Another situation you might see is that someone has a really low credit score, maybe too low, but their other financials are good. This is definitely something where you could say, hey, it's too low, we can't move forward. You send them an adverse action letter and you continue your search. Or if they align with everything else and they are maybe the first to align with the rest of your criteria, you could consider requiring a cosigner or a guarantor along with a higher deposit. Again, got to give you the caveat, make sure you are checking your local laws because this advice's mileage may vary. But inherently, what this does is this makes sure that you continue to get paid, even if the tenant themselves are unable to make the payment. So for example, or really to clarify, a co-signer on a rental property is someone who signs a lease with the tenant and assumes equal liability for paying the rent. A guarantor is only liable to make payments when the primary borrower can't or won't pay. So the cosigner is on the hook for anything in terms of the rent payments or damages, etc. Guarantor is only going to step in if things have really gone awry. Okay, so different levels. You also want to make sure that you understand in your area what rights the cosigner and guarantor have. It's entirely possible that the cosigner could have the right to live in the unit as well, again, depending on where you are, versus a guarantor, very rarely is that the case where they also have the right to live in the unit. All right. No, you might be saying, no, I think I would just toss them. I think if there's no credit score or if it's too low, I'm just going to toss them out. And I would say you're well within your rights. But just bear in mind that building up credit scores after missing payments can take a really long time for folks. And sometimes their credit scores are affected for reasons beyond their control. For example, if their spouse got diagnosed with a terminal illness and they racked up a whole bunch of hospital debt and they are struggling to pay it off, they are likely to have a lower credit score. But that's why it's important to make sure that you are really getting in there and doing a comprehensive look at this person as an individual. Take a look at their payments and recent pay stubs, get employment verifications, and actually talk with the tenant too. If they still don't align, that's okay. Make sure you send them an adverse action letter and continue searching for your next tenant. All right. So that was one batch of what ifs. Let's continue on to the juicy stuff. Like, oh, I don't know. What about evictions? So as I've noted here, evictions do stay on your public record for up to 7 years. Before we discuss what you should consider regarding eviction histories and tenant screenings, there is a bit of an uncomfortable conversation we need to have about evictions. Specifically, that they disproportionately impact marginalized groups in the United States and specific protected classes more than others. So specifically here, Black and brown households disproportionately get evicted in the United States, and unfortunately, Black women bear the brunt of this impact. So if we break it down with the figures, when I say disproportionately impacted, Black renters are about 19% of America's rental population, right? So if this was a proportionate impact, you would expect to see 19% of those evicted nationally are going to be Black renters. But that's not the case. It's actually 43%. And unfortunately, again, Black women with children are the most vulnerable group. In fact, according to data from American Progress, the Eviction Lab, and the National Partnership for Women and Families, 1 in 5 renters behind on rent and likely to face eviction in the United States are Black women. A recent study by the American Civil Liberties Union, or ACLU, found that in at least 17 states, Black female renters were filed against for eviction at double the rate of white renters or higher. New America underscored these findings in an article saying, quote, unpaid rent is the cause of most eviction filings and court-ordered evictions. For Black moms, this creates a compounded financial burden. Not only are Black mothers more likely to be evicted, but 68% of them are their household's sole or primary breadwinner. This earning obligation coincides with being on the short end of the racial, wealth, and pay gaps. Full-time working Black women earn 67 cents to the dollar as compared to their white non-Hispanic male counterparts. This limits the amount of money available for rent and affects any chance of building longer-term financial safety nets, such as an emergency fund to weather job losses. So, with all of this in mind, this disproportionate impact of evictions has led HUD to advise landlords not to blanket ban anyone with an eviction on their record. But what does this mean? Does this mean that you're not allowed to deny people if they have an eviction on their record? No, that is not the case. Instead, what I want you to do, if an eviction pops up, and this is aligned with HUD's recommendation, first and foremost, I want you to get curious. Is it just one previous eviction, right? From there, I also want you to see what the applicant has to say about it. How old was it? Was it something from, again, 6 years ago, or was it like last week? Like, what is the context of this eviction? You could also, and I highly recommend this, get in touch with the former landlord, especially if the applicant says that they resolved things with the evicting landlord after court. You could request a letter or a brief call with that housing provider. Bear in mind, some landlords may either just be completely disinterested and not want to talk or spend more time on the tenant, even if they came to a reasonable solution, but you will not know unless you reach out. You can also, I forgot to click. There we go. You can also require a cosigner and or increase the security deposit requirement, assuming that's allowed in your area. Again, please make sure that you are checking your local laws because your mileage may vary, particularly with the higher security deposit piece of that puzzle. All right. If they have more than one eviction on their record, let's say they have 3, 4, 5, at that point, it is very fair to evaluate the risk and say, hey, I I am not going to move forward. You do not have to tell the applicant why you are not moving them forward specifically. And we'll, again, touch on this when we talk about the adverse action letter in a little bit. You can just be vague and polite, remind them that they have the right to pull their credit history and to make requests to the credit union, or excuse me, the credit bureaus themselves if there are any kind of mistakes. That is not your job. You do not have to worry about mistakes on their credit report. You could just say, hey, I'm reminding you of your rights. Thank you for your time, and continue onward. Be vague but polite. That would be my recommendation. Okay, so we've talked about evictions. Now let's talk about crime. Okay. Once again, crime is something that is disproportionately impactful to various protected groups in the United States, which is why HUD is going to advise that everyone remember this fact and that they look at each case individually. So you want to see if there was an actual conviction. That's going to be important. If it's just an arrest, that's something completely different. You can ask about criminal convictions. You are not allowed to ask about arrest records. Okay. If you ask about criminal convictions, there must be a space on your application for the applicant to explain the situation and give you some of these details. But if you pull the report and you see that there is something on there, like a conviction, once again, look at how long ago that conviction was and the nature of the crime. Not all crimes are going to carry the same risk factors, but there are also quite a few different pieces of that to unfold. So we're going to continue talking about it. I also want you to check out if there's any evidence of rehabilitation. You know, did they serve community time? Did they go to jail and come back out? You really want to consider the applicant in full and treat it on a case-by-case basis. Okay, that is really important. Now, we say that because criminal backgrounds and convictions are not protected classes, right? They were not listed in our slide. However, it's important that you look at everything individually and make sure that you are just being as mindful as possible, and that you can, if push came to shove, explain to a court or explain to HUD why you made the decision that you made and how it was protecting your property, your tenants, etc. All right. So let's, again, continue to peel back these layers and talk about felonies. So, isn't any felony conviction proof of a threat? Isn't that proof enough of a risk? The answer is no. So specifically, HUD cites a study from the University of Minnesota back in the 60s about crime recidivism. Don't worry, that's a hard word to say. But inherently it means like the repeating of crime, right? So someone who's committing crimes again and again. They were trying to determine if what kind of risk factors there were, and specifically, is there a period of time that can pass after which the person who committed a crime is no longer at risk or no longer has the statistical risk of committing another crime. So David Pickron, the owner of Rent Perfect, spoke to the Rental Housing Journal about this a few years ago and said that the study quotes, if you commit a crime and you do not commit another crime for 7 years, your risk is the same as someone who has never committed a crime before. So as a landlord, if you go and you say, okay, well, I'm just gonna not accept anyone who has a criminal history in the last 8 or 10 years. If you get a complaint, HUD is gonna come to you and they're gonna say, explain to me why this is 8 to 10 years and not 7 years, like as we saw in this study. And there have really not been any additional studies that I could find since that prove that a longer period of time actually reduces the risk further. So that means that you can't just be like, well, I wanted to. I just wanted to have a 10-year window, and that's why I did it. No, HUD wants you to be able to explain and very specifically cite why you are making these choices. And with that in mind, any felony conviction needs to be investigated thoroughly, right? You have to prove that you are trying to reduce your risk. And right now, there are no additional cases that prove anything longer than 7 years reduces risk. Okay. So you can't blanket ban felons. It's true. You cannot blanket ban felons by and large, right? Like we're gonna we're going to get through this. There's a lot of information and a lot of discussion about what this means, particularly because, as I mentioned earlier, some crimes are riskier than others. So, according to legalinfo.lawyers.com, landlords should only consider whether the applicant poses a current threat to co-tenants, guests, and employees. For example, a recent assault conviction perpetrated on a neighbor's child would be arguably more relevant to a landlord than a 20-year-old conviction for armed burglary followed by a crime-free life. So, as you are getting into each of these cases as they pop up, ask yourself, does the applicant pose a current threat? All right. You are allowed to refuse applicants whose presence would endanger you, other tenants, etc. But you need to have a very clear tie and a very clear way of explaining that, because otherwise you could face quite a bit of issues. In fact, the Department of Justice recently reinforced its standing by suing the owners and managers of a Missouri apartment complex for discriminating against Black tenants over felony and criminal background checks by blanket banning felons per its October 3rd release. So that was just this month. Inherently, you want to make sure that you are making a compelling fact-based argument about the decisions that you make when screening tenants. So that means that there are some categories where you can say, yes, this is a high-risk situation, and so I am not moving forward. For example, lifetime sex offenders, recent methamphetamine manufacturers, and those with recent violent crime convictions could incur harm and increase liability. So make sure that you are checking with your local real estate attorney to be sure, but I'd expect that you're well within your rights to ban these applicants from living at your property before they've experienced at least 7 years of being in the community, crime-free. However, if they have continued offenses on their record within that 7-year time period, then you can just thank them and move them along. I will say as well, any kind of convictions regarding homicide and stalking, those are also ones that can usually just be turned away. I also have a depressing but important map here about the 2024 sex offender registry by state. Now, this one is also tricky because you want to make sure that you understand whether or not it is your responsibility in your state and county to look up someone on the sex offender registry and let the other tenants know if you find them there. However, there are some laws that say, hey, you are not allowed to use the sex offender registry to deny an applicant. So again, make sure you're checking with HUD, check with a lawyer to be sure if you have someone pull up and they match all of your other criteria, but they are also on this list. Talk to someone before you make any moves because these laws are surprisingly different in different areas. And you might even need to have language in your lease letting people know that you will be looking at the sex offender registry. So again, do your research. I have linked to the registry on this slide, but I also want you to make sure that you are having these conversations with experts in your area to give you the best, most applicable advice. Okay? All right. I know this is a rough one. So now let's go to something that's a little bit lighter, a little bit easier, and talk about international applicants. So we have the count here. When I asked my designer why, she said, because he's from Transylvania, which is fun and fresh and true. So when you have someone come in who doesn't have a social security number, that is a-okay. I would say make sure first and foremost that you are not asking about their immigration status or citizenship or requiring proof of legal residency, as that is illegal in some states. Please make sure you do your research because you want to make sure you are following these rules. And while some folks might say, well, if they don't have a social, I'm just going to turn them away. I would say maybe reconsider. There are other ways to validate their payment information, different things that you can do. We're going to talk about that, about what you can evaluate. And there are several different situations in which you might really be excited about international applicants. For example, if you provide student housing and the university that you are closest to has a really rich international program, you can cash in by providing fantastic housing and other amenities and still make sure that you're protecting your property by validating the person coming in. All right, I do have a note here. If you are curious, California Assembly Bill 976 prohibits landlords from screening tenants based on their immigration and citizenship status. So again, just make sure that you are checking your laws to see if anything like that exists where your rentals are. When it comes to actually vetting folks without a social security number, I will say first and foremost, unfortunately, you cannot use tenant screening through TurboTenant without a social security number. Alas, it makes me sad too. But because that goes through TransUnion, it requires a social. However, that doesn't mean you can't screen them. In fact, I would highly recommend that you collect some or all of the following, depending on what your comfort level is. You can ask for a copy of their passport and visa as applicable, as this will help verify their identity. You can also get a letter of reference from their previous landlord and validate their rental history, track their record as a tenant, maybe get a note from their last landlord, anything like that. You can also gather a letter from the lead's employer verifying their income. So this can help you feel more confident about their ability to pay rent. You, of course, can request 2 months of pay stubs. If they are here on an international program for school, there are similar letters that exist that can kind of detail how much money they are getting from that. And you can request those letters to further validate their income and make sure that they can afford it. Of course, you can also ask for a credit reference letter. So this details a financial relationship that the lead had with an individual or a business to illustrate their trustworthiness and ability to make payments on time. Asset documentation or a letter of financier support would certainly suffice. Lastly, ask them for a monthly billing statement. This can help you assess if they are keeping up on their bills. Something like a phone bill or a utility statement can show you if anything's past due on that account. And collecting some or all of these will give you a comprehensive picture of your international lead and see if they qualify for your rental. This is another situation in which it'd be really good to have a couple bullet points in your tenant screening document just so you can say, hey, this is how I treat it. This is what I look for. XYZ, cover your bases. All right. So we've talked a whole bunch about different situations. We've talked about some of the more common ones, from low credit scores to the more extreme ones like an eviction history that with a lot of different notes on it, and crime. What happens if you get an applicant and you do not want to move forward with them? Well, don't you worry. Just remember, first and foremost, you cannot deny them based on any of their protected classes. We've listed some of them here. What you need to do is send an adverse action letter. So this is just an example of a turn away for someone who you did not pull a credit report for, right? So this is just, let's say, the pre-screener. You didn't like their answers. It didn't align with what you're looking for. It is professional, it is vague, and it moves you along, right? However, you should make sure that you wait to reject applicants who pass your criteria until you have a signed lease, because you never know if your ideal tenant maybe all of a sudden has to move or do something else. And then if you've rejected everyone, you might have to start back at square one. But let's say that you've actually pulled their screening report. What do you need to do? Well, that's our old friend, the adverse action letter. So I have a screenshot up here, but don't feel like you need to read through all of it. Inherently, it is letting the applicant know that your decision not to move forward was made either wholly because or partially because of the information in their screening report that was provided by TransUnion, which is the company that we use for screening here at TurboTenant. It gives them some details about their right under the Fair Credit Reporting Act to obtain a free copy of their credit screening report, or excuse me, their consumer report. And if they have any issues with things that have popped up on that report, it reminds them that they can contact the agency and request changes or have a discussion with them accordingly. So that is not something that you have to do. And it gives them the information for TransUnion or whatever screening company that you have used if you are not using TurboTenant for free. So when you use TurboTenant, and let's say you've pulled a screening report, you're not going to move forward with them, you simply click a button and we send this out on your behalf. So that keeps you compliant because, again, this is a legal obligation that you have as someone using a credit report to pass along to them. So makes it really easy. You can just do it in a flash and not have to worry about your compliance, which is always a blast. All right, you guys have been a hoot. I know it is 12:02, but I want to get to some of your questions. So if you can stick around, I would love you to. Let's see here. Okay. Kimberly, can we adapt the TurboTenant pre-screen? So if you are a premium member, you can add additional questions to the pre-screener. I believe it's up to 4 questions. But yes. Okay. I really appreciate the kind words in the comments. This is not intended to be a political discussion. I know that there are a lot of hot and high feelings about that, given how close we are to the election. This is purely factual. I have listed all of my sources. So please, let's keep it to that. Can you report money owed for rent from lease violation early move out to a credit bureau, even if you don't pursue civilly? David, I believe the answer is yes. I believe so. Again, I would say get in contact with at least one of the credit bureaus. You could pick your favorite and ask them and see what the process would be. They are also likely to be able to tell you if you can do that with the other credit bureaus, although you might have to make similar phone calls. Excuse me. Okay. Got some good advice in here. Okay. Rayford, should tenants have good health insurance? You know, I can't say I've ever been asked that before. I hope for their sake that they do. It's not something that you could require as a landlord, but I would highly not, I do not recommend asking them about it, because it's a little bit invasive, but we hope you can require renter's insurance, and I would recommend doing that because that's more aligned with the actual property. All right, let me see. I know there are so many questions in the chat. I also want to check out the Q&A here, and sometimes it hides from me. Okay. All right. Does an owner with 3 or less single-family homes not marketed by an agent fall into the area of exempted from the Fair Housing Act for rentals? So yes, if you have a single-family home that you did not purchase using an agent, the seller did not sell using an agent, and you do not rent it out with a real estate agent, you are likely to be exempt from the Fair Housing Act. However, do make sure that you're checking with your local office because I don't want you to get into a bind. And remember that you cannot advertise anything that would be considered discriminatory. So you can't say like no men in this duplex in your listing, even if you are not screening them and you qualify to be exempt. All right. Similar question. If I am the president of a real estate corp that only deals with my own rental properties and have 3 single-family homes, am I exempt? The real estate company is only a management company to help put some distance from the fact that I'm the actual owner of the company. Daryl, I would say if you used a real estate agent or if a real estate agent was involved in the sale, check with your local head office, because it's, to me, I would, based on gut feeling in what you wrote, I would say you're probably not exempt, but it's hard to know without those details, and your local office will be able to help. Okay, let's see. At what point in the process are we required to give a response to someone who doesn't meet our requirements? For example, if someone has a credit score that is too low in a pre-screener, are we obligated to follow up? And if we find out during an application and background check, does that timing change things? I would say, let's separate. Okay, so if you put yourself in the applicant's shoes, I'd say giving them a response as soon as you know you're not going to move forward is the kindest way to do it. Just saying, hey, we've decided not to move forward. Thank you for your time. If you have not yet pulled their credit report. Now, the time that it becomes a legal situation is when you have pulled their credit report. Then you legally have to tell them that you are not moving forward with them and give them that adverse action letter. But if you see something in the pre-screener that doesn't align, just send them a quick message, vague but polite. Thank you for your time. We are not moving forward. Excuse me, and that should suffice. Marianne, the previous screen showed age as a protected class. Is that for all states or just some? That is only for some states. So Colorado, for example, has age as a protected class, but that is not the case. Only the 7 nationally protected classes are overarching across the United States. How do you print the Q&A? Well, don't worry. I actually include the chat in every single email to attendees. So you will have a chance to look at that. And Marianne, you will also have a chance to look at the adverse action letter in detail when we send over those slides. All right, let's see. Andrea, do not worry about missing the beginning of the meeting. We send out a recording within 2 business days of every webinar session, so you will get that as soon as we can get it to you. Okay. Julie, can you check on a co-signer's background when you are getting everything set up? Yes, so you will have to have them put in a, basically you'll screen them as if they were a tenant, and then you can evaluate from there if it's something that makes sense. If it seems like they don't have the income or they also have a pretty bad credit score, you can ask for a different cosigner. There are even some services that can act as guarantors. Now that is a paid service, obviously, that your tenant would pay for at that point, but if they don't have anyone in their life who can do it for them, that is always a possible solution. All right. So Linda, do you have a form that I can send a guarantor to sign? So they would be part of the lease in a way. So my understanding is that you could add a custom addendum and say, these are my expectations for the guarantor. They are expected to do X, Y, Z, and then have them sign that addendum along with the lease itself. That's also helpful so that you can make sure that everyone's on the same page regarding their rights to enter the property, things of that nature. So I don't believe you need a separate form. You can add it in as an addendum. Okay. Oh, I answered that one. That's good. Okay. Sorry, there's so many questions and I am so thankful that you guys have hung out, but let me answer just a couple more. Thank you for the kind words about my cat. Um, Julie, is there a required response time to send an adverse action letter? It should be as soon as you know that you're not moving forward with them and you have signed a lease with someone else. I can't recall off the top of my head if there is a stated timeline, like you have to do it within 3 days. I think it's just once there is a signed lease, at that point, you need to make sure that everyone else who applied and whose credit you looked at has received their adverse action letter. So that'd be my recommendation. Better to do it sooner once you have a full understanding of who's actually going to move in and the lease is signed. My house was bought through an agent. I do not live there, only 4 tenants. Kim, you are not exempted from the Fair Housing Act. All right. Okay, you mentioned that there's a place in TurboTenant that you can create notes like your requirements, etc. Where is this located? So I'm sorry, I should be clear. We have a document storage system. So you could type it up on a Google Doc or in Word or whatever your preferred text processor software is, and then upload that document to TurboTenant and it will live there in perpetuity. That's what I would recommend. Okay. Ooh, Robert, you asked about service animals. So your question for everyone else, how many service animals is too many for a single family home with 4 beds, 2 bath, 2,000 square feet, medium fenced yard? I love talking about service animals and emotional support animals. So let's make a couple things clear. When you say service animals here, a service animal is a trained dog or small pony that is medically necessary for their owner. So think about like a dog who can detect seizures. An emotional support animal it does not require any specific training. They are there to support the tenant's mental health. So when you say how many service animals, I think you actually mean how many emotional support animals, because typically what I've seen is that a person will have one service animal, but someone could have multiple emotional support animals. There is not a hard and fast rule about how many emotional support animals someone can have. Typically, you might see 1 to 2 per person. Really, more often you see just one. And there's not a hard and fast guideline about how many is too many for a space. I would say if you are concerned that there are too many emotional support animals because you don't have the space in that rental, that is typically a valid reason to deny them and say, hey, you've got like 4 Cane Corso dogs and they're not all going to fit in this space. I am concerned. But make sure that you're checking with your local HUD office because that can be kind of challenging and I want to make sure that you don't get in any trouble. Assuming legally allowed in state, if a tenant is adding a roommate, would you require a separate deposit? Uh, I would say no. Typically it's up to the tenants to discern like how they want to split the deposit. Um, and I don't think it would behoove you to separate that out, but if it's legally allowed, you can certainly think about it. I just don't think it'd be that great. And then you have to discern, like at the end, if you see wear and tear and it's in a common area, how are you going to tell which security deposit to take that out of versus just having one deposit? And you can say, okay, well, it doesn't matter if this was Jane. You both lived here. And so I'm taking it from the total sum. All right. Woo! You guys have asked some great questions. Okay. I got a judgment to have tenants evicted for non-pay. Does this automatically go on their credit reports? I believe so. I believe once a judgment is issued, that should translate onto their credit report. I don't know the timeline of that. I would assume it depends on the court system, and some of them are more backed up than others. But once there's a judgment issued, that should go on their history, is my understanding, Shirley. All right. I'm going to give you guys one more question here. While I do, since you've been so kind, I'm going to ask for one more kindness and just give you a quick final poll. We also have a survey at the very end of this where you can tell me what topics we should do next time around. I will give you a little spoiler before I answer another question. I'm really excited. Next month, we are going to cover how to find off-market deals with an expert guest. So that should be very exciting. Okay, what if a felony is pending? Yeah. So if a felony is pending, I would say, again, try and evaluate what you can. If you see kind of the nature of the crime, take a look at it. It's going to be hard to say until it actually moves through, because if it's in flux, if it's still being proven, then, innocent until proven guilty kind of deal comes into play. So tread carefully, talk to a real estate attorney and your local HUD office. Okay. Colorado law requires a portable screening report. Does TurboTenant allow and provide this so that I can accept or deny a tenant using Zillow or some other credit screening service? Yes. So we are in line with that, Robert. I'm trying to see if I can really quickly find you the support article. Actually, I linked, so after this webinar wraps up, you take a little survey to bring me joy. You will land on a landing page created by yours truly. And on there is an article about portable tenant screening, and you can check that out. If you still have questions, you can reach out to me. My email is Krista@turbotenant.com, and I will get you the support article that aligns with it. Okay. All right, that was the last question. You guys have been so generous with your time. I really appreciate you being here. I hope to see you for next month's webinar. And until then, please stay safe, be good to each other, and I will talk to you soon. Thanks, everyone.